The constitutionality of unnatural offences such as the homosexuality as a crime, Section 377 IPC was challenged before the Delhi High Court in 2001 and 2009. The Delhi High Court, after the considering various constitutional revision and new development, declared that the Section 377 IPC, insofar as it criminalizes consensual sexual acts of an adult in private, or violative in Article 21, 14 and 15 of the Constitution. It was to provide that the clarification in the judgment will hold till the Parliament chooses to amend the law of effectuate the recommendation of the Law Commission of India in its 172 report. However, the Supreme Court of India, Suresh Kumar Kosal versus Naz Foundation, reversed the Delhi High Court 2009 verdict held on the 150-year-old Section 377 criminalizing gay sex does not suffer from the vice of unconstitutionality. However, in the light of recent judgment, National Legal Services Authority versus Union of India recognizing the transgender community as a third gender along with male and female, the Supreme Court India agreed to reconsider its verdict. The Suresh Kumar Kosal versus Naz Foundation, the Constitutional Bench of the Indian Constitution and Supreme Court was the Navte Singh Johar, overruled Suresh Kumar Kosal and held the constitutional carnal intercourse among the adult in private space does not in any way harm public decency and morality. The court held insofar as the Section 377 penalized any consensual sexual relation between the two adults, be it is homosexual man and woman, heterosexual man and woman, lesbian woman and woman, cannot be regarded as constitutional. However, anyone engaged any kind of sexual activity with animals at the aspect 377 Constitution and it shall remain the penal offence. Adultery. In Joseph Sign, Union of India, another constitutional bench, the Supreme Court discriminalized adultery and held Section 497 of the Indian Penal Code unconstitutional as violated Article 14 and 21 of the Constitution. Before the strict term, the recognized of the offence was the limited to adultery committed with a married man, and a male offender alone was made liable to punishment. The Joseph Sign, the Supreme Court observed that the treating adultery and offences as the tantamount to the state entering into a real private realm, the Act, i.e., adultery does not fit into the concept of a crime. Adultery does not fit into the concept of a crime. It is treated as a crime, there would be immense intrusion into the extreme privacy of a matrimonial affair. It is better to left as a ground of divorce. The Supreme Court observed right to privacy. The right to privacy as a fundamental right established with the conclusive determine of the 9-judge bench judgment of the Supreme Court in K.S. Puttaswamy versus Union of India. The majority judgment and 5 concurring judgment of other judges have declared is no uncertain term and most authoritatively right to privacy to be a fundamental right. The judgment also discuss in detail the scope and ambit of right to privacy. The right of privacy, though the expressly granted in the Constitution of India, is now recognized as a basic fundamental right. Right to education. The Constitution 86th Amendment Act 2002 has inserted Article 21A, which is effective 1 April 2010, which provided that the state shall provide a free and compulsory education to all children of the age of 6 to 14 years in such manners as the state may law and determine. The right of a child should not be restricted only to free and compulsory education, but it should be extended to have quality education without the discrimination on the ground of child, economic, social and cultural background. The right of child to free compulsory education has now become a part of fundamental right under Article 21A of the Constitution. The total indifferences of the governmental authority is leading to violation of the fundamental right of a children. It is a constitutional obligation of the state to provide the free compulsory education of a children till they complete the age of 14 years. In a democratic society, a right of education is indispensable in the interpretation of the right to development as a human right. Thus, right to development is also considered to be basic human rights. However, in a 2012 ruling, the Honorable Supreme Court held that the right of children to free and compulsory education guaranteed under Article 21A Right of Education Article Education Act 2009 can be enforced against the school defined under Section 2N of the Act, except unaided minority and non-minority schools not receiving any kind of aid nor grant to meet their expenses from appropriate government or local authority. Apart from foregoing, judiciary always let us the advert to the safeguard which the Constitution itself has provided in Article 22 against the arbitrary arrest and detention. Hence, the case coming under Article 22 requirement of both Article 21 and 22 must be complied with. B. Procedural safeguard against the arbitrary arrest and detention provided for Clause 1 and 2 Article 22 are: no person who is the arrested shall be detained in a custody without being informed as soon as may be of the ground of such arrest. No such person shall be denied the right of consult and to be defended by a legal practitioner of his choices. Every person who is arrested and detained in a custody shall be produced before the nearest magistrate within a period of 24-hour arrest, excluding the time necessary for the journey from place of arrest to the court of the magistrate, and no such person shall be detained in custody beyond the said period without the authority of a magistrate. The above safeguards are not, however, available an enemy alien, a person arrested or detained under a law providing for a preventing detention. Right under Article 22 of 2 of Constitution is the available only against illegal detention by the police, and it is not available against custody in jail of a person pursuant to a judicial order. The Constitution itself authority legislature to make a law providing for preventing detention for a reason connected with the security of state, maintenance of public order, maintenance of the supplies and services essential to this community, or for reason connected with the defense, foreign affairs, or the security of India. 7th Schedule, List 1, Entry 9, List 3rd, Entry 3. So it would be competent to the legislator to enact that the person should be detained imprisoned without trial for any of the above reason, and the against such of the law individuals shall have no right of personal liberty. The Constitution, however, impose certain safeguard against the abuse of power. Article 22(4)(7). It is the safeguard which is the constitute fundamental right against arbitrary detention. It is because these the safeguard that the preventive detention has found a place in the part of fundamental right in so our Constitution. The relevant provision of the Article 22 explain as follows. When a person has been arrested under a law preventive detention, the government is entitled to detain such a person in custody only for the 3 months. It seeks to detain the arrested person for more than 3 months. It must obtain a report from the advisory board who will be examining the papers submitted by the government and by the accused as to whether the detention is justified. The person so detained shall, as soon as may be informed of the grounds at the detention, excepting that which the detaining authority considered to be against of the public interest, is disclosed. The detainee has the right to supply with the copies of all document, statement, material relied upon the grounds detention without delay. The person detained must be earlier opportunity making a representative against the order of detention. A law was the violate may be condition imposed. The Article 22 state above the liable to be declared invalid, and the order of detention which the violate any of these conditions will similarly and invalidated by the court with the detainee shall be forthwith be set free. Parliament has the power to prescribe the law the maximum period of which the person may be detained under a law of the preventive detention. Preventive detention means the detention of a person without trial. It is also called in order to distinguish it from punitive detention. The object of punitive detention of the punish a person for what he has done, and after he is tried in the courts for the illegal act of committed by him. The object of preventive detention, on the other hand, is to prevent him from the doing something, and the detention in this case take places on the apprehension that he is going to the something wrong and which comes within any of the grounds specified by the Constitution, act prejudicial to the security of the state, public order, maintenance of supply and services essential to the community, defense, foreign affairs, or the security of India. In fact, the preventive detention is resorted to such circumstances that the evidence of possession of authority is not sufficient to make charge or the secure of conviction of the detainee by legal proof, but may be sufficient to justify his detention on the suspicious maybe would be committed as a wrongful act unless be detained. Preventive detention is something unknown as the United States of America and the United Kingdom in time of peace. The adoption in India on a permanent footing of the power of the executive arrest person was a suspicious, which be tolerated in other countries. Only the emergencies cannot on the principle of justified by any other lover of liberty. But no longer assessment of the provision of our Constitution is possible without the taking note of the following circumstances. Firstly, detention without trial was not new idea introduced by the maker of our Constitution. For the first time, it was existence since the early days of the British India under the notorious Bengal Regulation 3rd of the 1818. Bengal State Prisoner Regulation and similar enactment in Madras, Bombay. History of preventive detention in India. History of preventive detention in India. Enactment Madras and Bombay, which laid no fetters upon the powers of the government to detain person or a suspicious. Then come Rule 26 of the rules framed under the Defence of India Act 1939, which authorized to government to detain person whenever it was satisfied with the respect to particular person that such detention was necessary to prevent him from acting any other manner of prejudicial to the defense and safety of the country and the like. This was the court's wartime measures modelled on the similar legislation in England during the World War II, was validity of which had been appealed in the House of Lords. But even after the cessation of the war, preventive detention was continued in India. It is an instrument to suppress apprehended breach of public order, public safety, and the like by the Provincial Maintenance of Public Order Act, under which there was a spate of litigation. A framer of our Constitution simply made it possible for such the legislation to be continued under the Constitution, subject to certain safeguards laid down therein, because they painfully visualized that the circumstances which had necessitated such as the abnormal legislation in the past, it had disappeared at the birth of Indian independence. It is common knowledge that the Republic had its birth amidst anti-social and subversive forces and ravages of a communal madness involving colossal loss of lives and property. In order to save infant Republic from the inroad of any such subversive element, therefore, the power had conferred upon the state, but the framers of the Constitution empowered upon the existing by law, subjecting the power of preventive detention a certain constitutional safeguard under the violation of which the individual could have right to approach Supreme Court or the High Courts, because of the safeguard are the fundamental rights for the enforcement of which the Constitution remedies Supreme Court, the High Court, because the safeguard of fundamental rights for the enforcement of which the Constitution remedies would lie. There have been a number of cases in which the court have nullified orders of preventive detention proceeding for the habeas corpus. Secondly, the above provision of the Constitution are not self-executory but require a law to be made by the legislator conforming to the condition laid down in the article, and the preventive detention can subsist only so long as the Indian Parliament, which constituted the law of preventive detention in India. It was a temporary act originally passed for 1 year only. Several times since then, the term of act was extended until the expired at the end of 1969. The arrival of anarchist forces obliged the Parliament to enact a new act named the Maintenance of Internal Security Act, popularly known the MISA, in 1971, having provision broadly similar in those of Preventive Detention Act 1950. In 1974, the Parliament passed the Conservation of Foreign Exchanges and Possession of Smuggling Activities Act 1974, commonly referred as a COFE-COSA, as the economic adjunct the MISA. While the MISA was a journal aimed at the subversive activity, COFE-COSA is aimed at antisocial activities like the smuggling, rocketing, foreign exchange, and like a MISA was repealed in 1978, but the COFE-COSA still remain. Further power, the preventive detention has been conferred on the central and state government safeguard defense at the security of the country and maintain security order, the essential supplies and services of enacting National Security Act 1980 and the preventing of the black marketing and maintenance of supplies of the Essential Commodity Act 1980. With the increase of terrorist activities, the government of India had to pass in 1985 the Terrorist and Disruptive Activities Prevention Act 1985, commonly called TADA. This was widely has been used to curb the terrorism. However, the TADA was repealed in 1995 for the same purpose. The Prevention of Terrorism Act 2002, commonly called POTA, was enacted 28 March 2002, but the 2 was repealed on 21st September 2004. It may be mentioned that the number of detention during the emergency of 76 has soared up to the 175 on the eve of coming to the power of Janata Party promised to abolish detention without trial. After coming to the power, the Janata Party come to realize the reality of problem. Eventually, in April 1975, the MISA was repealed by the parliament, but the government refused to repeal COFE-COSA because while the former related to political detention, later was aimed to social offences that required extra power of the check when influence and black marketing, smuggling and like were rampant. The provision of clauses 2 and 7 of Article 22 would not be allowed to be omitted so long as preventive detention was authorized by the COFE-COSA. The Janata government therefore sought to elevated the rigorous for the procedure for the preventive detention by effecting changes in clause 4 and 7 by enacting the Constitution 44th Amendment Act 1978, but the relevant provision of this Amendment Act could not be brought into the effect immediately since some changes in the machinery of the advisory board had to be made. Hence, the Amendment Act 1978 empowered the central government to bring into the force brought into the effective since some changes in machinery advisory board had to be made. Hence, the Amendment 1978 empowered the central government to bring into the force these provisions by issuing notification. Paradoxically, however, before any such notification could be issued, Janata government had its fall and Mr. Indira Gandhi returned in power 1980. The government has not issued any such notification, not with an adverse comment by the Supreme Court in view of the inordinate delay, the result of original clauses relating to preventive detention